The proceeding will start shortly. 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 The proceeding will start shortly.
Order, order. Helen Jones to move the motion.
Thank you, Mrs Moon. It's a great pleasure to be here under your chairmanship this afternoon. And I beg to move that the House has considered e-petition number 236592, calling for life sentences for causing death by dangerous driving. To lose a child is the worst thing that most of us could imagine. To lose a child at the age of only 4, mown down by a speeding driver, is something we don't even wish to imagine. And yet, that is what happened to Mr and Mrs Ewens, who started this petition. To listen to their story is to step into a world of horror. To hear about parents called to a hospital knowing something must be dreadfully wrong, to see their child grievously injured there, to have to follow the ambulance transferring her to Alderhay, unable to go into it because the doctors were still working to keep her alive, and to hear their story of lying with their daughter until she died, is just something for which I don't have the words to describe. I cannot even pretend to plumb the depths of their grief, but I do congratulate them on their courage and their tenacity in wanting something good to come out of that grief. They began that when they allowed some of Violet's organs to be donated after her death to save other lives. Many of them could not be used because her injuries were so severe. And they have continued it with this petition because, as they say rightly, they do not want this to happen to anyone else. Violet Grace was with her grandmother when a car doing 83 miles an hour in a 30-mile-an-hour zone mounted the pavement. The car was stolen and had false number plates on it. Violet suffered catastrophic injuries and died later. Her grandmother suffered life-changing injuries. But the driver and his passenger did not even attempt to help. They fled the scene. Indeed, there is evidence that they had to step over the bodies of their victims lying in the road to get out of the car. The driver, Aidan McAteer, fled to Amsterdam, as he said later, to clear his head and smoke some weed. Clearly, he thought this was all about him. Eventually, he returned to this country. He was tried and sentenced to 9 years and 4 months. His passenger got 6 years and 8 months. Neither of them showed any remorse, either at the time or later. In fact, they had their sentences increased while in jail for having illegal mobile phones and posting on social media. It doesn't seem much for a young life so cruelly taken and other lives destroyed in the process. Indeed, as Mr and Mrs Ewens said to me, they will be out in fact, having served less time than Violet Grace lived. Now, the law does not cope well with offences like these, and it leaves families believing they have not had justice and the public looking on in amazement at what seem to be unduly lenient sentences. I met some of the families today and heard their stories. It is a story in which families tell me they feel that they were treated as if they were the criminals, that they were not allowed to show emotion in court, sometimes told not to sit in the court. They were not allowed to read out all their victim statement in case it upset the perpetrator. They felt that they were the ones on trial some of the time. So these cases are not unique. There are a lot of them. And our justice system is simply not working for these people. Let me give some other examples. In February this year, a driver was sentenced for causing the death of a pedestrian and causing catastrophic damage to a house when he was doing twice the legal speed limit. He was a lorry driver, a professional. He got 10 years and 6 months. In March, Antonio Boparan was sentenced for causing the death of Cerys Edwards. She had only been 11 months old when he hit her in 2008. But she was held to have died later from complications arising from her injuries. He got 18 months, having previously served 21 months for dangerous driving. Families have told me this afternoon of seeing people cheer in court because their sentence was so light, of people who didn't go to jail at all. And that matters for confidence in our justice system. I know, it's a long time since I practiced law now, but I know from being around the courts that it is very difficult to make judgments on cases unless you have heard all the evidence. But I do believe that in the most serious cases, we ought to have life sentences available. Whereas Mr. Ewan said to me, in the wrong hands, a car is a lethal weapon.
On that point,
give way to my honourable friend, yes.
I am so grateful to my honourable friend for giving way. She is making an passionate and very moving speech, and I am really pleased to see so many families here. She, like me, will have spent far too many hours in grieving families' living rooms talking about these issues and their relatives taken away so swiftly. Would she agree with me talking about legislation? That those people who hire high-performance vehicles then should be held liable if those high-performance vehicles that they give to others are then used in criminal acts of murder on our streets.
I think my honourable friend has a very good point. There are many things that we need to do to reform the law in this area, and we have had a number of petitions on this issue about increasing sentences for death by dangerous driving, but also about imposing lifetime bans for people convicted of dangerous driving. I also had a letter from a lady called Amy O'Connor, whose brother, Andy, was killed when he was on his way to the gym one morning. It took 15 days to find the van and the perpetrator because the van had been hidden. By that time, of course, it was impossible to do drug or alcohol tests. And the only thing the driver could be charged with, and she quite understands why this was leaving the scene of an accident. Why, she asks, quite reasonably, do we not actually increase the sentence for people leaving the scene of an accident when they've caused death or serious injury? I will give way to the honourable gentleman.
To the honourable lady for giving way, and I congratulate her on the speech that she's currently making. Whilst we do need a change in the law to enable life sentences be available for death by dangerous driving, would you agree with me that actually in the worst cases of death by dangerous driving, I cannot understand why the Crown Prosecution Service does not charge with manslaughter, thereby giving the court a life sentence available for the worst types of offending?
The honourable gentleman has a very good point, and it's something that I'm going to be coming on to later in my remarks. I understand sometimes why it is difficult for people to understand the law in this area, because we often punish the type of driving, if you like, rather than the outcome. I mean, we used to have 3 offences at one time: dangerous driving, careless driving and reckless driving. But the offence of dangerous driving as it was then was abolished in the Criminal Law Act 1977 because it was felt there was not sufficient distinction between dangerous driving and reckless driving. However, very soon after that was done, it appeared to people that the law was not punishing the most serious cases effectively. In fact, a review of the law by Dr. Peter North in 1988 showed that many people thought that the law was not dealing with the most serious cases properly. And recklessness, obviously, is very difficult to prove. It's a subjective idea. However, at the time, government was very focused on dealing with drink driving, and I'll return to that later because I think we can learn some lessons from that. But it wasn't until 1991, in the Road Traffic Act, that the offence of causing death by dangerous driving was introduced. It was very clear, however, to many people that the law was still not being used effectively. There were widespread complaints that the CPS were often charging people with the lesser offence of careless driving because they felt they were more likely to secure a conviction. Now, there were attempts to address this with advice to Crown prosecutors in 2007 and again a revised guidance in 2013. And that revised guidance set out some of the constituents of dangerous driving, such as excessive speed, racing, aggressive driving, ignoring traffic signs or lights, failing to have regard for vulnerable pedestrians. Most of those were present in Violet Grace's case. There were also attempts through changes to advice from the Sentencing Advisory Panel to deal with people's fears. And it is fair to say that governments of all colours tried to fill in the gaps in the law so that it operated properly. For example, in the 2006 Road Safety Act, the then Labour government introduced the offence of causing death by careless driving and causing death by driving while unlicensed, disqualified or uninsured. In 2012, the coalition government, in the Legal Aid, Sentencing and Punishment of Offenders Act, introduced the offence of causing serious injury by careless driving. And in 2015, in the Criminal Justice and Courts Act, the offence of causing serious injury when driving while disqualified was introduced. It was punishable by 4 years, and a fine causing serious injury through careless driving was punishable by a sentence of up to 5 years. Now, all of these things were welcomed by road safety campaigners, and they had widespread support across this House. But they still did not deal with people's fears that the worst offences were neither being dealt with nor sentenced appropriately, even though in 2003 the maximum sentence for causing death by dangerous driving had been increased from 10 years to 14 years. And that matters. It matters because if the law is to work effectively, people have to have confidence in it. It has to do 3 things. It has to protect the innocent, but it also has to punish the guilty appropriately and to deter further offences. And there's a widespread belief that was not happening. And that was why, after a consultation, the current government announced in October 2017 that they would increase the maximum sentence for causing death by dangerous driving from 14 years to life. At the time, the Honourable Member for Esher and Walton, who was then a Justice Minister, said the decision had been taken to reflect the seriousness of the worst cases, the anguish of the victims' families, and the sentences for other serious offences, such as manslaughter. That would be introduced, he said, when parliamentary time allowed. The same thing was said in answer to a question from my honourable friend for Bradford South, who I know has campaigned on this issue also. So I have to say to the Minister, why the delay? Everyone currently in Parliament knows that when we are not debating Brexit, we have very little business at all. This is something that could be dealt with very swiftly, almost a one-clause bill. It would get widespread support across the House. It would have the support of the general public. I know there are other issues the government wants to deal with, but why wait for a big bill when we could get on and do this now? Surely we don't need to wait for someone else to be killed, God forbid, another child to be killed, before we act. In fact, I would go further, as the honourable gentleman previously mentioned. I think in cases like the Violet Grace case, where the car was stolen, clearly evidence of criminal intent, had false number plates, went through 2 red lights and was doing 83 miles an hour, and when the driver had previous criminal offences for burglary and for failing to comply with a court order, they should have been charged with manslaughter. This was a criminal act by a known criminal with complete disregard for other people's lives. However, that is not what the petition is asking for. It's simply asking for life sentences to be made available for this offence. Now, it is also asking for a minimum tariff of 15 years. And I have to say, I think that is a little more problematic. Now, generally, our law does not set minimum sentences. It sets maximum sentences. And it leaves it to the trial judge, who's heard all the evidence, to set the tariff. Clearly, if we went down this road, there would have to be changes to the sentencing guidelines to reflect that. But my fear about setting a minimum tariff is it might have the opposite effect to what is actually intended. It might make juries more reluctant to convict in some cases, and it may lead back to the situation we've seen before of people being charged with careless driving instead of dangerous driving. I think the same problem comes with calling for consecutive sentences, or at least a similar problem. Normally in our law, sentences are served concurrently for convictions arising from the same incident, consecutively if they arise from different incidents. My fear is if we went to sentencing concurrently for offences, I understand entirely why families feel this, where you've had someone killed and someone else seriously injured, the tariffs would actually be set lower, and therefore you wouldn't necessarily achieve what you want to achieve. But that can be looked at, it can be considered. What is clear, though, is we should get on with increasing the maximum sentence. But that by itself is not enough. I referred earlier to how we had tackled drink driving in this country, where we did 2 things. We made sure, well, we brought in the breathalyser and made sure there were serious sentences available, but we also did a public education campaign, which in the end changed people's attitudes. It used to be quite socially acceptable to knock back a load of pints and get behind the wheel of a car. It isn't now. I'm not saying it doesn't happen, but it is not any longer socially acceptable. We need to do those 2 things. Mr. and Mrs. Ewins are already doing their part by speaking at speed awareness courses to alert drivers to the damage that they can do. We need to do our part as politicians as well and have a proper public education campaign, because the aim in the end surely is not to have lots of people serving life sentences. It is to deter them from committing the offence in the first place and save people's lives. So I do say to the Minister, please, can the government now get on with this? I know that they are looking at other things to be included in a road safety bill, such as dealing with cycling and so on. Those things are very worthy in themselves, but they are delaying action on something that many of us believe needs action on now. By doing it, the government would have the support of the public. It would have widespread support amongst all parties in this House. It would rebuild confidence in the law, and it would recognise the campaigning of the bereaved families. Most of all, most important of all, it might save lives. And surely even saving one life makes it worth doing.
Very good, well done.
The question is that this House has considered e-petition 236952 relating to dangerous driving. James Heapy.
Thank you very much, Mrs Moon, and can I congratulate the Honourable Lady on an excellent speech to open this debate. She's done great justice to all of those who I know have travelled from quite a long way in order to hear this debate had in Parliament, and I thought she opened the debate brilliantly. It's also a pleasure to serve under your chairmanship. It's unfortunate that I should be called so early in proceedings because I'm going to talk about something ever so slightly different, but very, very important to constituents of mine. My constituents, Tom and Jackie Luxon, were involved in a car crash with their then 2-year-old daughter. The force of the impact was so huge that the ISOFIX that the 2-year-old was travelling in broke, and she sustained life-changing injuries that initially had caused paralysis. She, amazingly, in the 2 years since, has recovered to some degree. But there is evidence that the person who hit the Luxons that day had been driving for 16 miles dangerously before the moment of the collision. And the reason that this incident was brought to my attention was that Jackie was 26 weeks pregnant at the time of the impact, and her baby, Grace, was stillborn as a consequence. Now, we're today debating whether or not there should be life sentences when dangerous driving is obviously the cause of the death of someone who is alive. But Grace, who was 26 weeks in gestation at the time of the impact, was killed, obviously, as a direct consequence of the impact, and the man responsible received 3 years and 7 months in prison for that. If Grace had taken just one breath when she made it to hospital with her mother, if she'd been delivered and taken just one breath, then this debate would have applied. We'd have been talking about whether or not that man should have been liable for a life sentence, or whether, as is the current situation, something less satisfactory. But in her case, she didn't take a breath, and 3 years and 7 months was all that could be served on that man for killing her. Now, PCO in Davis, who was the investigating officer for Avon and Somerset Police, wrote to me in despair. I hope he doesn't get in trouble for this with the Chief Constable, because he did exactly as a police officer should do and showed just how much he cared. And he wrote to me and said, "Myself and the Crown Prosecution Service looked into charging the driver with death by dangerous driving, but we hit a brick wall when we discovered that the Road Traffic Act 1988 does not recognise a healthy 26-year-old unborn baby as a person. Instead, we had to charge him with causing serious injury by dangerous driving, ×2, for the mother and for the daughter, with nothing able to be charged for the death of the baby." Now, Mrs Moon, a couple of weeks ago, I was able to ask the Prime Minister a question about this in Prime Minister's questions, and the Prime Minister gave me a very considered answer. But the key thrust to her answer was the danger that any such discussion about the rights of unborn children leads to unintended consequences. That was the far as the Prime Minister went in her answer, and she's obviously talking about abortion law, and I agree with her that the impacts can be very, very challenging indeed. But Mrs Moon, there is precedence, and it's great to see the Minister of State in his place, and as such a distinguished practitioner of the law, I know that he will see that there is an opportunity to get this right. In the Infant Life Preservation Act of 1929, a fetus is viable at the age of 24 weeks. That's what it says in the law. And there is wording in that act that is very explicit, that sets out clear exemptions, precisely so there are not unintended consequences of that definition. It's also worth noting that in that awful tragedy at Grenfell Tower, a stillborn child as a consequence of that tragedy was also officially recorded as a victim. So there is precedence. There are examples in law where it is possible to recognise the rights of an unborn child. And I beg the Minister that in considering the wider merits of the case that's put today in this debate, which is hugely important, it should be possible to give life sentences. It should be the norm to give life sentences for dangerous driving. Cars can be a weapon in the hands of the wrong people. But in the case of the Luxons, when their child was denied to them at 26 weeks gestation, and the punishment for the person responsible was just 3 years and 7 months, I urge the Minister to look beyond what we do for the punishment received by those who kill those that are living, and also look at the punishment we give to those who are stillborn as a consequence of these collisions. Thank you.
Mary Rimmer.
Thank you. It's a pleasure to chair under your chairmanship, and may I compliment the member for Warrington North for the excellent introduction and the work that you've obviously put into this. Pay tribute to the other members forward. It is a pleasure to speak under your chairmanship. Before I begin my speech, I want to take a moment to praise the 3 people who have made this debate happen: Rebecca and Glenn, who are both sat in this hall today, and Violet Grace, whose tragic and senseless death is the reason this debate is taking place. I also want to praise everyone who signed this petition, the St Helens Star and the whole St Helens community for supporting Rebecca and Glenn, combined with the tireless work of Rebecca and Glenn to get this e-petition signed, to get this debate, and their tireless work to help prevent it happening in future. They are driven to get the law changed, to get a sentence that fits the crime. That is what we are asking for today. As the petition states, life sentence for death by dangerous driving, a sentence that will hopefully deter others from reckless driving, so that what happened to Violet Grace might not happen to another child. And should it happen again, that those responsible receive a sentence that fits the crime they have committed, to give them time necessary for them to reflect and be rehabilitated and have proper regard and consideration, understanding for their actions. The law must be improved for victims and survivors. In this case, the defendant's barrister objected to the parents reading out their full impact statement, arguing that the defendants would find it too upsetting. The judge accepted this, and the CPS barrister gave the parents a copy of the victim impact statement, with parts they could not read out in open court highlighted. The whole purpose of the victim's impact statement is about the impact on the victims and the survivors, not the defendants. Guidance should be given to the judiciary that the overriding consideration is on the victim and their family, and not the impact statement may upset the defendants. A sentence that fits the crime, that is what we are asking for today. Violet Grace was a beautiful, angelic-looking 4-year-old child. You may find this upsetting, for my family have not been able to say this and have it heard. 4-year-old child, and on Friday the 24th of March, she was simply walking home from preschool, calling at her aunties and a 4-year-old cousin with her Nan. Nan had lifted up Violet Grace to carry her safely across the road, had not put a foot on the road when she was struck by a stolen vehicle, recklessly driven at 83 miles per hour in a 30-mile zone, and had collided and mounted the pavement. The stolen car that had struck them was fitted with false number plates and a cloned key. The driver had no licence, no insurance. The Independent Police Complaints Commission reported later there had been complaints about the car being driven dangerously since noon that day. The driver and his passenger then fled the scene, running over Violet Grace, who had been thrown 50 yards away. The passenger ran back to the car, stepping over the child again, to retrieve a bag that he needed from the car. The whole incident was witnessed by Violet Grace's 4-year-old cousin. A fireman working in the area heard the noise, saw 2 young men running at speed. He ran to the main road, finding the scene and Violet Grace, and worked along with the local dentist to resuscitate her. The driver fled the country, travelling to Amsterdam to clear his head by getting some weed, and then fled to Alicante. Glenn Ewins receives a phone call at work telling him to get to Wiston Hospital urgently. Rebecca, working in Warrington Hospital, receives a similar call. She sets off driving, sobbing, and spots a parked police car. She gets out, banging on the windows and pleading for help. The police take her under blue light to Wiston Hospital. Violet Grace's injuries were horrific, and it was essential to move her to Alderhay Children's Hospital. Rebecca and Glenn were told Violet could not survive her injuries. They know Violet Grace as a loving, caring child, always wanting to help others. They courageously decide to donate her organs to help save other young children's lives. They say that is what Violet Grace would want. It is suggested to Rebecca to get into bed with Violet Grace, and she's reluctant with all the tubes and the equipment around. She is persuaded to do so, and she prays and pleads, "Please breathe, please breathe." Violet Grace passes away, the local priest, Father Tom Nayland, saying prayers around her. He checks the time, and it's 23:58 on the 25th of March, and he says, today is the day Angel Gabriel came down on the 25th of March to tell Mary she's to have a baby called Jesus. And the family weep. Violet Grace was Angel Gabriel in her school's nativity play. She was so pleased and used to dance around while singing, "I'm the boss of the angels, I'm the boss of the angels." Her kidney and pancreas were donated to save the lives of 2 other young children. Nan, a nurse who trained at Great Ormond Street Hospital, suffered numerous injuries, was in a critical condition. It was a miracle she served, but with life-changing injuries. Grandad, a university lecturer, has had to retire to take care of Violet Grace's Nan. All this while the driver was in Amsterdam, clearing his head. Earlier, I stated that all we are asking for is a sentence that fits the crime that has been committed. The 2 men responsible for Violet Grace's death will serve less time in prison than she was alive, less than 4.5 years. In fact, by pleading guilty and good behaviour, the driver might even be out sooner. I ask all those of us here today, is this truly a sentence that fits the crime that has been committed? I believe that most, if not all of us, would say no. And clearly, the 164,632 people who signed this petition would agree.
Will my honourable friend give way?
I will.
Can I thank my honourable friend and neighbouring MP for her work on this issue and reiterate what she says about the support of the entire community across St Helens for the Ewins family, and I think in Warrington and Wigan, across Merseyside and the whole North West too. But can I say to her as well as our sympathy and solidarity and the outpouring of love there has been from our community for the family, there is also a deep sense of anger about how they have been treated and a determination to make sure no other family is ever treated like that again.
I thank the member for standing and saying this. Thank you so much. Current laws around sentencing for dangerous driving are simply not good enough. We need to equip our judges with the sentencing guidelines that enables them to provide that key tenet of our judicial system, justice. The Ewins praise the judge and say he actually said his hands were tied. Now I'm sure an argument would be what constitutes dangerous driving. What if I sneeze and lose control of my vehicle? Will I now face these increased sentences? My simple answer to this question is no. What we're talking about here today is giving the option to judges through the Sentencing Council guidelines to issue a higher sentence where they deem it just. A judge will consider all the evidence provided to them and pass a sentence that is appropriate to the crime committed, whether that be the minimum sentence or the maximum sentence in the guidelines, as with any other crime. What I and many others here today are arguing is that the maximum sentence that a judge can issue for dangerous driving is far too low. When we look at the sentencing around gross negligence manslaughter, judges have the option available then to issue life as the maximum sentence, with a range of sentencing options below it, 1 to 18 years, I understand. I do not see how a lower sentence can exist in the sentencing between dangerous driving and gross negligence manslaughter. Both involve a disregard for the lives of others, and as we too often see, both can lead to the death of innocent people, where an individual's direct, reckless and callous actions have led to the death of another, such as stealing the car, driving 83 miles an hour, 30 miles zone, leaving her with life-changing injuries and suffering and death of an innocent 4-year-old child. How can we not give the option to our judges to deliver a sentence at least on a par with gross negligence manslaughter for dangerous driving? Another issue I wish to raise on behalf of Rebecca and Glenn, which I believe falls under the remit of this debate, is that of concurrent sentencing. Rebecca and Glenn and many people think it is unacceptable that criminals can serve 2 sentences at the same time, describing it as a buy one, get one free. The crux of this issue is that the current legal system does not adequately explain to victims what is happening, and thus it does not appear to be delivering justice it is supposed to. I will.
Thank you. I thank the honourable member for giving way. I just can't imagine the pain and hurt felt by the parents of Violet Grace. As the honourable members just indicated, the government promised to introduce life sentences for death by dangerous driving and to create a new offence of causing serious injury by careless driving 2 years ago. Many families across this country, including my constituent, Mr Addy from Burscough, whose daughter was mown down in 2016 by a driver who received a fine of £500 and no jail sentence. All these people are waiting for these promises to become law. Does my honourable friend agree that not only do we need the appropriate punishment, but effective deterrence for dangerous and careless driving, excessive speeding, reckless joyriding, and we need it now? Everyone's waited long enough.
I do accept what the member's saying, and people are feeling this. The crux of this issue is that the current legal system does not adequately explain. I think I've said that once. I call on the Minister to explain why concurrent sentences are used to my constituents and to investigate how our judicial system explains its practices to victims. The arguments that I and others have made here today are not calling for a knee-jerk change of the law. We are not arguing for punishment for the sake of punishment. What we are merely arguing for is a sentence that fits the crime that has been committed. We are not under any illusion around the impact this change will have on preventing dangerous driving. Changing the sentence around dangerous driving may only deter a few people from driving dangerously, but those few people changing their behaviour could save lives like Violet Grace's. Therefore, if it saves more lives, surely it is worth it. And it will also send a clear message to those who might consider driving dangerously that we as a society see it as being morally abhorrent. For those who don't change their behaviour and cause death by dangerous driving, by changing some sentencing rules, guidelines, we will finally be able to deliver some justice for families like the Ewins and all those who are affected by such recklessness. It cannot be acceptable that individuals such as those that struck down Violet Grace and tore open the Ewins family can serve less sentence than the time that she lived. When they have sentenced Rebecca, Glenn and Oliver and her little brother Oliver to a life of grief, denying them the joys of watching her grow up and bring all the joyous occasions and events a maturing daughter gives to a family, a loss that can never, ever be repaid in this life. In October 2017, the government pledged to increase sentencing by death. sentencing for death by dangerous driving to life, yet we have not seen any meaningful movement on this issue in nearly 2 years. I therefore call on the Minister opposite to set his civil servants to the task of getting the laws around dangerous driving changed. This is a gap in our legislation and a gap in our justice system that needs to be filled, and sooner rather than later. I do understand issues such as Brexit will put a strain on the departments as a whole at Parliament. We must not allow this vitally important issue to be lost in the miasma of current politics. Rebecca and Glenn want the change in the law to be done properly and as quickly as possible. This government has a duty to get this done, because the longer we leave this, the longer our judicial system fails to deliver some of the justices that families such as Ewins and all those families we've met today deserve. And while we can never fill the wound that has been opened, we must improve justice for victims and survivors and show that we care for them.
Liz McInnes.
Thank you, Mrs Moon, and it's a pleasure to serve under your chairwomanship. Now, first of all, I want to express my heartfelt sympathy to the family of Violet Grace, and indeed to all the families who are with us today. No parent should have to endure what they've endured. And it is to their credit that they have created this very successful petition to try to get some justice for families who have lost loved ones to death by dangerous driving, and also for those who have endured serious and life-changing injuries. Sadly, Violet Grace's story and the pain and sense of injustice of the bereaved family is all too familiar to me. In 2014, my constituent, Joseph Brown-Larty, was killed by a dangerous driver. Joseph was just 25 years old, with a promising career opening up ahead of him. Yet his plans and his life were destroyed by an uninsured, unlicensed 18-year-old named Adil Haroon, who chose to drive a hired, high-powered car at 80 miles per hour in a 30-mile-per-hour zone, running a red light and smashing into Joseph's car. The impact was so great that Joseph's car was split in two, and tragically, Joseph was killed outright. Police officers who attended the scene said it was the worst crash they had ever seen on an urban street. Adil Haroon was convicted of causing death by dangerous driving, but was given just a 6-year jail sentence, of which he will serve just 3 in custody, being released on licence after serving half his sentence. Now, Joseph's parents, Dawn and Ian Brown-Larty, contacted me for help after this derisory sentence was given. I wrote to the Attorney-General asking for the sentence to be reconsidered in view of the gravity and tragic consequences of the crime. The reply I received was that the judge had been acting within sentencing guidelines and that the sentence had not been unduly lenient and would not be reconsidered. Now, as we've heard, the maximum sentence that can be given for causing death by dangerous driving is 14 years. Yet very few convictions result in a sentence of this length. In 2017, the average length of sentence was just 4 years and 9 months. Joseph's parents, with the help of the road safety charity Break and campaigning journalist Michelle Livesey, launched a petition and a campaign called Justice for Joseph, calling for tougher sentences for causing death and serious injury by dangerous driving. The petition gathered 20,000 signatures and was handed into Downing Street with support from me and from the then Police and Crime Commissioner for Greater Manchester, who is now my honourable friend, the member for Rochdale. Break, the road safety charity, then launched another campaign named Roads to Justice. And for the launch of this, Joseph's parents allowed the wreckage of Joseph's car to be displayed outside Parliament. And some honourable members may recall the shocking sight of a wrecked Audi split clean into two on their journey into work that day. And that wreckage is now being used by Greater Manchester Police as part of their road safety campaigning and teaching, kindly donated by Josie's family in the hope that it will serve as a lesson to other drivers. And in response to this pressure, because sadly many other MPs have had similar tragedies in their own constituencies, the government held a consultation on sentencing for causing death and serious injury by dangerous driving. Around 9,000 responses were received, and it took many months to process them all. But everyone involved in the campaign was delighted when the Ministry of Justice announced in October 2017 that as a result of the consultation, the maximum sentence for causing death by dangerous driving would be extended from 14 years to life. Joseph's parents felt that all their campaigning had paid off, and although nothing could bring Joseph back, or bring justice in his case, at least the heartache of seeing their loved one's killer receive a derisory sentence would not happen to another family bereaved in those terrible circumstances. Yet since then, what has happened? Despite numerous questions being asked in the House by myself and other MPs, the constant refrain from the government has been that they will bring legislation to the House when parliamentary time allows. Yet this is a government which has presided over hours and hours of parliamentary inaction, with sessions closing early and the business of the day being wound up mid-afternoon on numerous occasions. There has been ample parliamentary time to bring this new legislation, yet nothing has happened. The change was promised in October 2017, and we are now 21 months on with nothing having changed. And the tragedy is that we are still seeing deaths, like those of poor Violet Grace, as some drivers simply do not get the message that in the wrong hands a car is a lethal weapon. I do strongly believe that longer sentences would reinforce that message. At the moment, I believe that some drivers have an extremely careless approach to driving in an extremely reckless manner because they know that if they cause an accident which kills or maims, that they will only serve a relatively short sentence. This has to change. Families like the Brown-Lartys in my constituency and the Ewans in my honourable friend St Helens constituency need to see justice being done. And if I have one question for the Minister, it is this. When is the maximum sentence of life for causing death by dangerous driving, as announced by the government 21 months ago, going to be brought to Parliament? And I would add that a response of when parliamentary time allows simply isn't good enough. These families need to see justice for Joseph, for Violet Grace, and for all the other victims killed or maimed on our roads by the scourge of dangerous driving. It's time that the punishment fitted the crime.
Judith Cummings.
Thank you, and it's a pleasure to serve under your chairmanship, Mrs Moon. Can I thank my honourable friend for Warrington North for moving this debate on behalf of the Petitions Committee so eloquently. I'd like to begin by paying tribute to the family of Violet Grace, who was tragically killed by a dangerous driver in March 2017, aged just 4. Her mother and father, Rebecca and Glenn, started this petition when the driver was sentenced to a derisory 9 years and 4 months in prison after driving a stolen car, mounting the pavement and fleeing the scene and subsequently the country. Violet Grace's killer was convicted of causing death by dangerous driving, and I, along with many other honourable members and campaigners, have long campaigned for the reform of the sentencing guidelines connected to this offence. As it stands, the maximum sentence for causing death by dangerous driving, that is driving which falls far below the expected standard, is just 14 years. As we have seen in this and many other cases, too often killer drivers are actually given considerably less than 14 years. It is not right that people who drive recklessly with no regard for human life and cause death and serious injury get away with lenient sentences because our sentencing guidelines are just not tough enough. This is why I warmly welcomed the government's announcement in October 2017 that it would bring in tougher sentences for drivers who kill someone through dangerous or careless driving, as well as the announcement of a new offence of causing serious injury through careless driving. My simple question to the Minister is, it's nearly 2 years on. Where are these tougher sentences? The Government has repeatedly said it will bring forward legislative proposals as soon as parliamentary time allows. I sincerely hope that this is not a phrase that we will hear from the Minister today. As we all know, there has been ample parliamentary time in recent months for these changes to be discussed, debated and implemented. One could fairly conclude that the Government, having announced it intended to introduce these tougher penalties, has now changed its mind. This is an appalling way to treat these families affected by this terrible crime. I've used this quote before, but I will say it again. It's from a family member of an 81-year-old man who was killed by a speeding driver in 2017. And he said, "The Government's delay in implementing tougher penalties has denied my family the justice that we need. The Government has a duty to families like mine to ensure that justice is delivered by bringing in these new laws now, not several months or years down the line. There can be no excuse." Exactly right. There can be no more excuses. Many of us here today will know the lasting pain and loss of losing a loved one so brutally. I struggle to explain to bereaved relatives in my constituency why the Government is choosing to delay. So either the Minister should announce today when he intends to bring forward proposals for tougher sentences for Parliament to consider, or he should be honest and say that the Government no longer intends to do so and explain why. Judges recognise the inadequacy of the current sentencing guidelines and want to be able to hand down these tougher sentences so that the laws of the land reflects the severity of the crime. As it stands, families are being let down, denied justice, and the Government's inaction is making their suffering worse. This Government may be in its last weeks, but it still has time to right this wrong and get these changes on the statute book. So I'm asking the Minister today to leave a legacy for this Prime Minister's Government and introduce these tougher sentences without delay. Thank you.
Colleen Fletcher.
Thank you, and thank you, Mrs Moon. It's a pleasure to serve under your chairmanship, and I pay tribute to the bereaved relatives who are with us here today, those who have suffered pain and hurt. In October 2017, the Government announced proposals to increase the maximum penalty for causing death by dangerous driving from 14 years imprisonment to life, increase the maximum penalty for causing death by careless driving under the influence of drink or drugs from 14 years imprisonment to life, and create a new offence of causing serious injury by careless driving. It is now 2019 and we are still waiting for these changes to be implemented. The Government constantly tell us we will bring forward proposals for reform of the law as soon as parliamentary time allows. When will that time be? As far as I am concerned, these proposals are necessary to improve safety on our roads, act as a deterrent to would-be offenders and restore fairness to our justice system. Moreover, they enjoy wide cross-party support and are therefore relatively straightforward to implement. There is simply no excuse for the continued delay. Let's be clear. While the Government dithers, families continue to see the killers of their loved ones receive paltry prison sentences, which simply adds to their grief and their sense of injustice. Like the Platt May family from Coventry, 2-year-old Casper and 6-year-old Corey Platt May were two lovely little boys who lived in my constituency, not very far from where I was brought up as a child, only yards. In February last year, they were killed in a horrific hit-and-run incident at the hands of a driver who had no licence or insurance, was doing more than 60 miles per hour in a built-up residential area, and was high on cocaine at the time. The driver was given a meagre 9-year jail term, which was increased to 10.5 years on appeal. while the Plackney family was sentenced to a lifetime of grief at the loss of Corey and Casper and suffered the double injustice of seeing the perpetrator receive a prison sentence of just a few years, Casper and Corey's mother, Louise, said, "What our family has had to go through and will continue to experience for the rest of our lives highlights the need for the toughest possible sentences to be handed out to drivers who ruin lives. We call on the government to honour Corey and Casper's legacy by ensuring its proposals for tougher sentences for drivers who kill are made law as soon as practically possible. It is time for the government to heed that call, to honour Corey and Casper's legacy and introduce this legislation immediately so that drivers who kill are jailed appropriately. While it is true that no sentence at all can alleviate the anguish experienced by the love of a lost one in such horrendous circumstances, a lenient sentence can and does add to a family's pain. Families are being ripped apart through tragedy, and although nothing can bring their loved ones back, an appropriate prison sentence which more closely reflects the severity and impact of the crime and which keeps the killer off the roads and prevents them from causing similar misery to another family will surely bring them a semblance of comfort. It is in the government's gift to provide that comfort to these grieving families, to make our roads safer, and to put in place a law that is both a proper deterrent and a punishment. I urge the Minister to act without further delay.
Fitzpatrick.
Pleasure to see you presiding this afternoon, Mrs Moon, and I'm grateful for the opportunity to briefly contribute to this debate. And I also pay my tribute to the petitioners. I want to thank BREAK and the Parliamentary Advisory Council for Transport Safety for the briefings, and to the Petition Committee for facilitating this debate, and to my right honourable friend from Warrington North for our excellent introductory speech to the debate. And I'm very pleased to follow my honourable friend from Coventry North East. My concerns generally, Mrs Boone, apart from the specifics from the briefings which I'll come on to, is that government generally, this government in particular, and in society, we do not attach enough seriousness to road deaths, let alone those caused by dangerous driving, which cause even more pain. If there were 1,500 deaths a year in aviation or in trains, there would be a demand for public inquiry. In terms of the numbers of road deaths stagnating in recent years, we need to address this issue much more seriously. The government's refusal to set a target for casualty reduction since 2010 abandoned a 30-year consensus started by the Thatcher administration in the 80s and supported by all governments since, is indicative of the coalition and now the Conservatives government's relaxed approach. We had seen a gradual reduction in road deaths over the decades, but since 2010 that has stalled. Our general attitude to road deaths is far too complacent, and it sends all the wrong signals. It creates a climate that road deaths happen, and when committed as part of another crime, it's just not condemned as heavily as it ought to be. It's almost that these deaths, these murders, are obscured in all the deaths which are happening on our roads. And road crashes is the cause of more deaths amongst young people than anything else. The government had proposed a green paper for graduated licences for new, mostly young drivers, to impress upon them how serious a step it was getting behind the wheel of a vehicle. The green paper disappeared. We don't create the appropriate attitude in our new drivers, that they are in charge, as many colleagues have said, of a lethal weapon. And if they use it to cause harm or death to others, there are serious consequences. Just as we don't approach it appropriately from an educational or training point of view, neither do we do so from a legal one. We need to approach driving much more seriously. I have to say I'm not in favour of mandatory sentences generally. I believe the bench and judges should have the discretion. But if it was my family, my child or my grandchild who was a victim of some of the atrocious crimes that we've heard today, I would want the full extent of the law used against the criminals who perpetrated that crime. And I would want the penalty under the law to be appropriate, as so many colleagues have indicated earlier on. The law is lacking, to say the least, and the government knows this. They've been promising change for years. The question to the Minister, who is held in high regard across the House as a man of integrity, is when does it happen? If I can move briefly to the briefings, particularly the Brake briefing. Brake says death and serious injuries on a road cause terrible suffering every day. The suffering is often compounded by flawed legal framework, which lets serious offenders get away with pitiful penalties and allow dangerous drivers back on our roads. We're calling on the government to fully implement the tougher sentences for killer drivers it announced in 2017. Two of the demands are to bring forward legislation to implement maximum sentences, and the second one to simplify and improve legal definitions of unsafe driving behaviour, specifically the use of dangerous and careless. Brake goes on to say it cannot be right that the average prison sentence for a driver who has killed someone through dangerous or illegal driving is 4 years, especially when we consider that the minimum sentence for domestic burglary with no additional charge of bodily harm is 3 years. It's a very powerful point, Minister. They go on to say that in 2014, point made earlier on by my honourable friend, the then Secretary of State for Justice promised a full review of all road traffic offences, yet this promise remains unfulfilled. Why? Brake then raised the 2016 consultation and say that Brake does not, however, agree with the government's contention in their response that there is a risk that juries may be less willing to convict. They say juries would be able to receive clear direction that a range of penalties would be available in sentencing, with precedent shown, negating this as an issue. Brake then discussed the question, and the important question, of careless and dangerous driving being an issue, and called to simplify and improve the legal definition of unsafe driving. They say the maximum sentence for causing death by careless driving is only 5 years, compared to 14 years causing death by dangerous driving. And they discussed the contrast between the two, i.e., since it was introduced in 2008, Brake found that in the first few years after the new charge was introduced, the number of death by dangerous driving convictions dropped off as the number of death by careless driving convictions increased. In 2007, there were 233 deaths by dangerous driving convictions. This then fell to 114 in 2011, where there was 235 deaths by careless driving convictions. The question is there a conviction that one's coming down and the other one's going up, resulting in lower penalties for those who've been found guilty of a less serious offence? So Brake thinks there's a relationship. Perhaps the Minister could comment. Additionally, they say the use of the term careless in cases where driving has resulted in death and serious injury undermines and trivialises the gravitas of the offence and its impact on victims and their families. The Minister, you know, language is of critical importance, and careless, in inverted commas, careless just doesn't convey the seriousness of the crime, and I agree. So in conclusion, Mrs Moon, the issue is hugely important to the safety and well-being of all of our constituents. The government has been making the right noises and the right promises. So many deaths caused by human actions, speeding, no seat belts, drinking drugs, mobile phones, all deliberate human actions. Maybe not criminal, maybe not serious enough for the most important offence to be charged, but deaths caused by human beings who are making decisions because they do not care about the rest of us. And these people need to be brought to book. Will the honourable gentleman allow? I'm very happy to give way to the honourable gentleman, of course.
Not for the first time in this chamber. I agree with everything that the honourable gentleman has said. Clearly, we must bring forward these changes to the sentencing guidelines. And I've listened to some incredible contributions. I just wonder whether he is aware of the Don't Motor on Meds campaign, which has not been mentioned during this, which is the role that prescription medication can have in dangerous driving. It can often create, unwittingly, lethal drivers. And I just wonder, yes, the government can act to change the sentencing guidelines, but the pharmaceutical industry, for instance, could act quickly now to much more clearly label medication as not safe to drive. Many of the charities are very good at doing that, but many of the pharmaceutical companies bury it in the small print. And that is something, because we're all about prevention, as well as, of course, the right punishment when these tragic events happen.
The right honourable gentleman has an absolutely appropriate point, Mrs Moon. There is individual personal responsibility by individual drivers that when they get medication, they need to make sure that it does not impair their judgment and they are not a risk to others on the road. Pharmaceutical companies have a role in this because they should be printing large warning labels on that medication to say, do you know this means you're not fit to drive? GPs have a responsibility to report drivers who are not fit to drive to the DVLA, whether it's for eyesight, whether it's mental health issues, whether it's other problems that individuals have, and the individual has their own responsibility. So this is right across the piece that we all need to recognise that there are problems. One of the issues I've been looking at recently is more frequent testing for over 70-year-olds, because there have been some cases in the press of older drivers driving up motorways the wrong way and causing death. The evidence from other countries said if you introduce testing, mandatory testing for all over 70s or over 75s, and they pass, then they think that they've got a licence to go back to driving how they were when they were 45 or 50, and it actually has a counter effect, and therefore it's not always easy to identify simple solutions, because in this there are no simple solutions. We're driving vehicles that can kill people, and the responsibility lies with us as well as other people and other family members to make sure that when we get behind the wheel we are safe. But that's not what we're talking about today, Mrs Moon. We're talking about criminals who are deliberately doing things that they ought not to be doing and causing death and destruction and grief and bereavement to decent families across the country. And what we need to do as a parliament, and I do not point the finger at the Conservative government because this has affected all parties and all governments, we need to make sure that we have the right penalty to fit the crime, because if we don't, then people outside will feel that they're not being well represented and will be forced into taking action themselves. I believe that we need to approach driving differently, educationally and culturally. Great progress has been made in improving the driving tests, practical and theoretical tests in recent years, but there's more to be done. And we must remember we have among the safest roads in the world. We are usually in the top 3 in terms of safe roads, but we're still killing 1,500 people a year, and dangerous drivers, criminal drivers, are among that, and they're hidden among that, and they should be taken out and identified and highlighted so that, as everybody has said in this debate so far, they act as a deterrent to other people committing the same crimes. The punishment at this point doesn't always match the crime, Minister, as everybody has said. The petitioners are waiting to hear what the government intends to do, and I, like others, as I have said, have high regard for the Minister, and I look forward to his response, which I hope will give us all some reassurance. Mrs Moon.
Thank you, Mrs Moon. It is a pleasure to serve under your chairmanship and to follow my honourable friend in what was an incredibly powerful speech. And I'd like to extend my sympathy to the families here today. The tragic case of Violet Grace and the others we have heard like it illustrates starkly the devastating results that can occur when people recklessly ignore the rules of the road and drive dangerously on it. It is also a reminder of just how important it is to get the law right, and in this context, it is increasingly clear that that simply is no longer the case. The sheer weight in numbers of the public who have thrown their weight behind this campaign shows the strength of feeling for a law befitting the crime in instances of death by dangerous driving. And sadly, it is a feeling known to many of my own constituents, because in Barnsley East, We too have shared in our own tragedy. According to House of Commons figures, there were 293 traffic accident casualties in my constituency in 2017. 62 of these were serious and 4 were fatal. The following year, Brearley's Jacqueline Wellman was hit and killed by a HGV lorry stolen by 4 men who joy-rode the vehicle around Barnsley for 2 days. They damaged cars, injured pedestrians, nearly killed a man, and only came to a stop when they crashed into a house travelling at least twice the speed limit. Sadly, this was not before they hit Jackie on her daily walk through the village and killed her. All 4 men had existing criminal records, with nearly 100 convictions between them, some for driving offences, including 1 for death by dangerous driving. 1 pleaded guilty, the other 3 were convicted likewise. But the plea deductions and time on licence all will serve between 5 and just over 6 years. It is a huge blow to an already grieving family. Jackie's life taken, while their lives have been torn apart since that day. It also goes without saying that Jackie's family have wondered, had one of those involved been given a longer, more appropriate sentence for his first conviction for death by dangerous driving, he may not have been free to require a second. The turmoil they have gone through is indescribable, and what's more, the judge who sentenced those responsible agrees. His hands were tied by the 14-year maximum sentence for death by dangerous driving, and the increase he admitted was unfortunately a matter for Parliament, not for him. So what are we waiting for? Expert judges, the public, as demonstrated by the support for this petition, MPs across the House all support an increase in the maximum sentence for death by dangerous driving. But perhaps most importantly, so do the government. And it is they who have the power to do so. And I know the Minister is aware of how important this is, having met with myself and Jackie's family just a few weeks ago. So I implore them, let the cases of Jacqueline Wildman, of Violet Grace, and of the others tragically killed by dangerous driving not be ignored. Increase the sentences now, provide a genuine incentive to avoid driving dangerously, give judges the ability to take those who do so off our streets, and do everything we can in this House to ensure nobody else has to suffer like the families that we have spoken of today.
David Drew.
Thank you, Mrs Moon. I'm delighted to serve in your chairmanship. Sorry I missed the first 2 minutes, but I was otherwise engaged. And I'd like to thank the mover of the motion, who has put this very movingly about how serious this is, and also all the other honourable friends and members who've spoken. Now, I just want to look at 2 issues. I want to look at some numbers to start with, because we haven't really talked about numbers. And these numbers are a bit dated, so I hope the Minister will accept that they will obviously be greater than they are. But between 2016 and 2017, there were 90,000 people approximately banned from driving in this country. That's out of a driving population of 33 million. Now, I estimate that to be 0.002% of the driving population. To get a ban, you have to get 12 points. Or, dare I say, to be convicted of a very serious driving offence. Now, of those who've got 12 points, my figures tell me there are something like 11,000 people driving with more than 12 points because they've been let off for one reason or another. It's interesting to know, and I know this won't necessarily cover the complete brief of the Minister, why people get let off quite so easily, because they do, because anyone who pleads that will have an injurious effect to their employment can get away with numerous points above 12. I do think that needs looking at. Now, in terms of people who have been disqualified, in the last, and this comes from Freedom of Information, so I have to estimate that it's right. In the county of Gloucestershire, there were some 300 people over the last 4 years who were caught driving while disqualified. Nationally, that figure was said to be 38,000. So these are considerably high numbers of people who chance it, who've got a ban, who should not be driving. And my view of driving is it's a privilege, not a right. And yet they flagrantly disregard that and are caught again, and presumably that some further action is taken against them. So my first point is there are an awful lot of people who drive whilst disqualified or take huge risks because they're not really suitable to be driving, now for whatever reason. I've not got into the age issue that my honourable friend mentioned, and that's another thing. People who really, because of their age deficiencies, because that's what happens when we all get older, some of us recognise that, they perhaps should be taking the decision not to drive at all. So we've got a huge cultural problem of very few people being banned, and even when they are banned, they'll risk it for whatever reason. We have to change that culture. In the same way with drink driving and drug driving, we have to nail people because they are not just threatening their own life and limb, they're threatening other people's as well. My second point is that I've done a lot of work with my local road safety groups, and I've mentioned before, indebted to a gentleman called Charles Pedrick, who spends hours and hours and hours of his time on local road safety issues, to the extent that he visits parish councils, he visits local road safety groups, a number of whom have taken on the opportunity to install ANPR cameras, automatic number recognition cameras, or have taken, the handheld devices. What they found out is that, dare I say, most people drive reasonably safely. Even though they may slightly speed, they're largely within the safety, the safety parameters. But there is a minority who drive exceedingly dangerously, not just occasionally, but on a very regular basis. And these people get caught out by the ANPR staff. Now, at the moment, volunteers can do very little about that. Even the police can't do much about it because these are voluntary activities, so to speak. What the police now do in my area is to go round on a knock on the door and saying, we've got you N number of times. If you carry on this way, you will cause a serious accident. Normally, it has the desired effect and people say, sorry, I shouldn't have been doing it. I have learnt my lesson. Sadly, in the minority of cases of the minority, there are people who just flagrantly break the law, don't care at all, because they think they can get away with it. So I'm asking the Minister, I know it's not his direct responsibility, he's going to have to talk to the Home Office and other elements within the, within the law enforcement area. But it would be very helpful if these voluntary groups are given some traction over how we can chase down dangerous drivers. Because unless you stop these people at source, they will continue to drive dangerously. And it's important that these people who give off their time to check up on people who speed, they have the satisfaction that something happens as a result of it. Because these will be the people who kill. Because they don't care. And unless we stop them, they will kill as an inevitable consequence. So I hear all the heartrending stories and I feel total sympathy from it. But we have got to stop these people at source. They should lose their licence and they should go through the due process until they've learned to drive responsibly. They shouldn't get their licence back. And more particularly, the people who actually track them should have some satisfaction that something is being done about this. Because the frustration they have is really, it's only the knock on the door by the police. That's as far as it goes. You can't prosecute. These are purely voluntary activities. But we know who these dangerous people are, and we should be doing something about it. So I hope the Minister hears my plea, will get some activity going so that the ANPR information is shareable and is usable, so that we can at least know that people who drive dangerously cannot get away with it. So that's my plea. I hope the Minister will have some good things to say about that.
Drew Hendry.
Thank you, Mrs Moon. It's a pleasure to serve under your chairmanship today. Can I also congratulate the petitioners and, of course, the Honourable Member for Warrington North for leading this debate. She said in her opening remarks that to talk about this was to step into a world of horror, and I think she underlined some of that when she was talking about the heartbreak of families such as those of Violet Grace. And like many others, my sympathy goes with her to those families and to others who've been similarly affected by such criminality, because that's what it is. She described the selflessness of the organ donation following that incident, and put it in sharp contrast with the incredible speed and criminality and heartless cowardice of those who perpetrated what is in fact a heinous crime. She went on to talk about the failures of the justice system, which are rightly and always have been different in Scotland, so I won't talk too much about the ins and outs of that. Regulations, of course, are set by the UK government, but the law is different. But lessons and comparisons must be made wherever people are driving, and wherever accidents and indeed criminal acts occur when somebody is behind the wheel. We should always these comparisons should always be drawn, and action should always be taken to make our roads safer. She talked about the need to deter further offences and mentioned education campaigns and drink-drive actions, which I want to talk about in a minute or two. But first I want to recount the words of the Honourable Member from St Helens South and Whiston, who talked about Rebecca and Glenn, and indeed Violet, and all the people who signed the petition. She talked about the balance of impact on victims versus the defendants, and gave more details of the terrible events surrounding the incident with Violet Grace. The Honourable Member for St Helens North talked about the understandable rise in anger in the communities. And other Honourable Members talked about how their constituents were similarly affected. The Honourable Member for Haywood and Middleton talked about the terrible case of Joseph, whose car was put on display outside Parliament for everyone to see, and that was a particularly heartbreaking sight to witness, but one that we don't get if they put every vehicle that was involved in something like that outside, we just wouldn't be able to contemplate the amount of carnage that goes on through drivers being irresponsible, or, as indeed I've said many times and will say many times in future, through criminal acts behind the wheel. The Honourable Member for Coventry North East talked about some serious and troubling crime involving drug use on the roads, and recounted the story of poor little Corrie and Casper. And this has been quite a difficult debate to listen to when you've heard about all the personal tragedy that's involved, and you think about the issues that then go into wash into families, into communities, and the devastating impacts that has on people's lives out with the initial incident, but going on perhaps even for generations afterwards. She talked about how they'd been mown down when they'd barely started their lives. The Honourable Member for Barnsley East talked about previous convictions being hardly acknowledged in another tragic case. And the Honourable Member for Stroud talked about the band drivers disregarding the law and the need to change the culture. And a minority of people driving dangerously regularly. Some could be educated, but a further shameful minority just ignore that. And he also mentioned the help needed for voluntary groups. The Honourable Member for Poplar and Limehouse made a very powerful contribution, as has been mentioned, but talked quite rightly about the need for greater seriousness over road deaths, and talked about targets required by the UK governments for casualty reduction, and went on to talk quite rightly, which I want to just now talk about education, training, and of course the law, but also the cultural change that's required. The Honourable Member for Warrington North, when she started this debate, talked about no need to delay action. And there is indeed no need to delay action. Things can be done. They don't have to wait for other bits and pieces to fall into place or other issues to be dealt with. In Scotland, there has been action taken on some of the issues that the Honourable Member for Poplar and Limehouse was talking about. The Scottish Government is committed through Scotland's Road Safety Framework to 2020 to achieving safer road travel. The framework sets out Scotland's first ever national casualty reduction targets, and I wonder if the Minister might let us know if he's going to follow that lead in this instance. The SNP Scottish Government have taken a wide range of actions to reduce road traffic accidents in Scotland, including cutting the blood alcohol limit and introducing drug driving limits in 2019. And I'll give more detail on that in a moment. And that has resulted in the number of people being killed or injured on Scotland's roads reaching the lowest level since records began. In Scotland, by the nature of our geography, road safety is an everyday issue. Now, most of us use the roads every day as drivers, passengers, cyclists and pedestrians. And for many people, it's the main way of getting to their jobs, and indeed some of them doing those jobs. So the Scottish Government and road safety partners are committed to the outcome of safer road travel in Scotland for everyone. And to this end, the Scottish Government has produced, as I said, a framework for improving road safety over the next decade. It describes the road safety vision for Scotland, aims and commitments, and of course those targets that I mentioned for road death reductions. They will also seek to establish a drive for life culture, which will seek to influence young people's attitudes to road safety and future driving behaviour before they get behind the wheel. They'll conduct a public debate on young driver issues, including graduated licences and additional training, and encourage the support of the Royal Society for the Prevention of Accidents Scotland, with the formation of the Scottish Occupational Road Safety Alliance in order to raise employers' awareness of the needs to have a policy on managing the occupational road risk. They'll also investigate ways to promote and facilitate initiatives relating to further training for older drivers, including consideration of an incentivisation in order to do this. Now, the Honourable Member for Warrington North, when she was talking about those shocking and desperate acts, also talked about the need to reduce accidents. And specifically, I think it is important to reflect on the legal blood alcohol limit in Scotland, which has been reduced from 80 milligrams per 100 millilitres to 50 milligrams per 100 millilitres, lower than the rest of the UK. Incidentally, England, Wales and Northern Ireland still have that 80 milligram limit, which is the joint highest in Europe. In Scotland, making that change has seen a reduction of 7.6% in drink driving in 2015 compared with the previous year. At that time, the Transport Minister, Humza Yousaf, announced plans also for a cycling task force, the main aim of which will be to drive forward ambitious cycling infrastructure, such as segregated cycle paths. Because although dangerous driving is the focus of this, rightly the focus of this very debate just now, we mustn't forget that there are other road users that are at danger on the road from both those dangerous drivers and other irresponsible driving behaviour. In Scotland, the SNP MSP Gillian Martin has brought forward a members' bill to the Scottish Parliament to require seat belts to be fitted in all dedicated home-to-school transport in Scotland. The bill receives royal assent in December 2017, and in 2019 the Scottish Government introduced drug driving offences. By the end of this financial year, we will have spent over £8.2 billion on Scotland's motorways and trunk road networks in order to improve road safety, including the M8 missing link, the Queensferry crossing, and one that's very important, Mrs Moon, in my constituency, which is the road safety cameras, the average speed cameras, which have been put in place on the A9, which I can tell you, for the Minister's ears, if he's looking for an example of something that has changed driver behaviour quite dramatically, those average speed cameras are now welcomed by the community because they see the difference they've made in terms of adjusting the behaviour, both of people who are using the roads regularly as locals and those who are visiting into the area. So there has been excellent progress, but there is always more to do. We're not content to say that it's now at the lowest level since records began, that we have to do more in order to maintain that improvement. So the Scottish Government has been working with the Welsh Assembly on those casualty reduction targets. Official figures revealed that, as I said, that we've had a drop, but we intend to continue the work to improve that. Mrs Moon, I hope that the Minister will answer the questions about the legal issues that have been raised by honourable colleagues in this chamber today. He will take notice of the passion of the petitioners, the heartache of the families, and of course the pleas of the honourable members right around this chamber, and I'm sure across this Parliament, who want to see action taken to not only to prevent further road deaths, but to actually tackle those people who are flouting the law quite deliberately and affecting people's lives in many ways. So I thank you for this opportunity, and I look forward to hearing about that and also about what the Minister is going to take into account of the lessons that may be learned from Scotland. Thank you.
Thank you, Mrs Moon. It is, of course, a pleasure to serve under your chairwomanship. And can I also thank all the honourable members from across the House that have spoken in this very important debate, making some very powerful points, starting off with my honourable friend, the member for Warrington North, who I think did justice to this debate in setting a tone that I felt was substantial and set the direction for us to have a really serious conversation, but actually one that isn't one that is productive, and I hope we will reach somewhere that goes in that direction. Can I also pay tribute to the petitioners, the parents, the friends, family of Violet Grace, and the strength and courage that I think you've shown in what must be the most difficult period for any parent, friends and family, and I believe my honourable friend, the member for St Helens, in her very emotional and moving tribute and speech today, set out those circumstances that anybody could not be do anything other than be moved by. And of course, other honourable members, I think honourable members again from across the House have each gone through some truly horrific and tragic personal cases that they have had to deal with. And as I look towards my honourable friend for Bradford South, we in Bradford are no different and have had some truly tragic events and cases. And can I also pay tribute to those road safety campaigners such as Brake, who my honourable friend from Poplar's and Limehouse referred to quite a lot, and also pay tribute actually to the campaign run in my own district and that of the honourable member for Bradford South, the Telegraph and Argus newspaper, who have led calls locally not just for much stronger sentences for dangerous drivers and those causing death by dangerous driving, but for increased resources to the police to enable them to crack down on dangerous driving, a point I'll substantiate a little later. Mrs Moon, those who drive dangerously and those who sit behind the wheel while under the influence of drink or drugs do so with no thought for the consequences of their actions, and they care little for the lifetime of grief and misery that they can end up causing for the friends and families of those that they kill with their reckless actions. For whilst they never set out with the intention to kill, it is the way in which they conduct themselves behind the wheel that makes it such a very real possibility. Yet despite the life-shattering consequences of death as a result of dangerous driving or careless driving under the influence, the sentence that such an offence attracts in reality is far from what the public both expect and want, with those who have killed through dangerous driving receiving a custodial sentence of just a few years in many cases, as we've heard here today. Now, I want to be clear, the offence of causing death by dangerous driving and of causing death by careless driving whilst under the influence of drink or drugs should be treated with the severity that it deserves, with a severity that matches the consequences of their actions. However, whilst we must be careful not to tie the hands of the judiciary too tightly, as we must respect their independence and ability to view and give judgment upon cases based on the evidence and facts that are brought before them, we must give them the power and flexibility that they need to pass sentences that fit the crime of which the defendants are convicted. Because of the backlash, Mrs Moon, that some members have referred to today over such short sentences imposed for such serious crimes, in 2014 the government, quite rightly at that time, stated their intention to launch a consultation on this matter. Again, something that many honourable members have gone through the whole chronology. And if I could just perhaps go through the pertinent points within that. It took a further 2 years for this consultation to be published. A further year for the government to respond to the findings of the consultation to be published. And despite the fact that within just days it had already become one of the most widely responded to consultations the Ministry of Justice had ever issued. Now, despite it now being 4 years on from the government's statement on their desire to increase the maximum sentence available to judges, we are still no closer to the legislation bringing such a desire into effect, another point made by many honourable members. And now we hear that they will bring forward legislation when parliamentary time can be found, stating as much to a number of honourable members, including my honourable friend who's not in this place today, for gelding. But they've been using that excuse now for 2 years, and I think the point has been made. I think we've had time has been abundantly present over the last couple of years, and the government has had plenty of time to bring this legislation, yet they have refused to do so. Perhaps the Minister will explain why, leaving their words and promises to the friends and families of victims ringing hollow. Now, I mean, to be fair to the Honourable Minister who's in his place today, he wasn't in this role at that time, and so I'm not levelling any criticism directly at the Minister. Like I said before, I think this issue is of such seriousness. I think we can work together on this issue, and that's why I'm hopeful the Minister, when he does respond, will make a contribution that I think perhaps everybody would want him to make today. The other issue that perhaps hasn't had as much airtime here today, understandably, but I think is one that is very important also to make, is the massive cuts to police numbers. And I genuinely, again, don't try to stand up and use it in a political context, but actually make the factual point. Since 2010, 2.7 billion in real terms has been cut from police budgets across the country, and we know that there's 21,000 police officers were lost for good. In my own region of West Yorkshire, 700 fewer officers. These cuts have also fallen the hardest on specialist forces who are much harder to recruit, train and replace, such as our road traffic police, who, according to the Times, have seen an 11% drop between 2016 and 18. And their losses keenly felt on our streets, where their reassuring presence no longer deters dangerous drivers. The Police Federation themselves have warned that dashcam evidence from drivers is no replacement for patrols with motorists regularly driving in an antisocial, dangerous and aggressive way, because they're just not being caught and because they are less and less fearful about being caught. And evidence shows that increased levels of road policing can reduce traffic violations and road casualties. And we all know that prevention is better than cure, and we don't want to be in a position of sentencing those found guilty of causing death by dangerous driving, because by then it's already too late. The irreversible damage has been done and another life has been needlessly lost. Instead, we want to be in a position where those who would otherwise be driving dangerously are deterred from ever setting out on the road because of a near certain chance of being caught doing so. And we want to be in a situation in which such drivers are never able to take another life. In addition to putting police back on our streets and on our roads, we also need to look at cases of dangerous driving where death or injury, thankfully, doesn't occur, and look at what is driving people to make such foolish decisions when behind the wheel. Such offences may warrant, quite rightly, a custodial sentence, depending on their severity. What they do warrant are much greater rehabilitative efforts to make sure that the next time a dangerous driver gets behind the wheel, they don't repeat their mistakes, they don't drive dangerously, and they don't end up killing someone. In conclusion, Mrs. Moon, those killed by dangerous drivers or careless drivers under the influence of drink or drugs deserve justice, real justice, and the friends and family of these victims deserve to see those whose reckless and dangerous behaviour has left huge holes in their lives punished for those crimes.
Minister.
Thank you very much indeed, Mrs. Moon. It is indeed a pleasure to serve under your chairmanship, but a greater pleasure to thank the Honourable Lady, the member for Warrington North, for moving this debate in what was a sensitive and sensible speech. She used her experience in the law to helpfully give us a pen portrait of the evolution of driving legislation in England and Wales, and she was right to draw this House's attention to how the law has evolved in this area. When we take the steering wheel of a car or a vehicle, Mrs. Moon, it means that we all assume a responsibility. We assume a responsibility to any passengers in the vehicle. We assume a responsibility to other vehicle users. And we assume a responsibility to pedestrians, and finally to that wider society. Driving law rightly criminalises what we would regard as unacceptable behaviour. It also rightly draws distinctions between types of behaviour. But where I readily accept the law gets into difficulty is where we have a combination of extreme culpability, extreme blameworthiness in the manner of driving, and that extreme level of harm that can be caused by that degree of very bad driving, dangerous driving as we now call it, reckless driving, as indeed the Honourable Lady referred to it prior to its reform in 1991. And that is a difficulty which I myself have grappled with, not just as a Member of Parliament serving my constituents, but also as a professional, as a member of the criminal bar, called upon to prosecute these cases, and indeed in my latter incarnation as Her Majesty's Solicitor General. But before coming on to those particular examples, I want to add my own tribute to the families of the victims of these horrendous crimes who have come here today, who have supported petitions calling for reform, and who have with extraordinary dignity exemplified all that is good in our society, all that is positive in our world, despite the horrendous experiences that they have gone through. The offence of causing death by dangerous driving is a particularly unusual, sensitive and difficult scenario. Because all of us here, in this room or outside, could at some stage suddenly find ourselves in the same scenario as the families here today and the thousands of families who are not here with us today, but who share the same experiences. Suddenly, without any warning, They're drawn into an entirely different world, a world of police and criminal justice, a world of procedure, a world of court proceedings that they never expected in the month of Sundays they would become involved in. That, I readily accept, can only add to the sense of loss, of grief, of suffering that the families endure and continue to endure very often many years after the incident itself. It is a particular set of circumstances that I think all of us struggle to put into words and to even come fully to terms with. I still struggle now, even though it's probably a quarter of a century since my first direct contact with a family who has suffered in this way. And there is frankly nothing that a court or indeed this House can do to right the wrong that has been done to them. Having said that, merely acknowledging that is never going to be enough. And that's why we, as parliamentarians, as legislators, must do all that we can to not just mitigate the circumstances, not just to try and create a degree of justice, but also to send a wider message to society that the system does support those who suffer, does work in their interest, and does at least try to deliver the highest degree of justice. And that is why I was particularly struck by the conversations I had this afternoon, and I'm grateful to the Honourable Lady, and indeed the Honourable Lady, the member for St Helens North, for allowing me to come and meet the families. It was extremely useful, informative, and I felt very much the better for having heard what they had to say. And I pay warm and meaningful and deep tribute to them. To answer the question directly, and the question that was put by the Honourable Lady, the member for Bradford South, the government has not changed its view about the need to reform the law of causing death by dangerous driving. It is our settled intention to increase the maximum from 14 years to life imprisonment. The issue is when. I want to do this as soon as possible. I would like to see legislation done in a swift and effective way. And my offer is this, to all honourable and right honourable members here, indeed right across the House of Commons, to work together to make sure that any bill that is introduced can be dealt with as speedily and expeditiously as possible, without, and with the greatest respect to honourable members who have a right to amend any bill that they see before them, without a plethora of amendments and other issues that could, of course, either impede or slow down the process of that legislation. That's my request, that's my offer, that is what I would very much like to work with members opposite upon in order to achieve our common goal. And I'll give way to the Honourable Lady.
Ms McGuinness.
I'm grateful to the Minister for giving way, but I think he's just struck an unnecessarily adversarial tone. I think it's very, very clear that there would be cross-party support for this. It was welcomed in October 2017, and I don't think he needs to concern himself that certainly that anyone in the Labour Party, and I'm sure I speak for the SNP as well in this case, I don't think anybody would try and do anything to impede the progress of such a bill. We just want it to come in as soon as possible.
I'm really grateful to the Honourable Lady, and I certainly wasn't suggesting in any way that honourable members of any party would want to impede it. The point that I'm seeking to make is that we can achieve this with a broad and deep level of consensus. And I absolutely take her point, and I embrace what she said. And I know that having listened carefully to the speech she made, she comes at this with entirely the right and appropriate sense of inter-party and intra-party cooperation, and I'm very grateful to her, and I'll give way to the Honourable Lady.
Thank you, and I do thank the Minister for accepting my intervention. I think what Speaker after Speaker, the point that we were making is when, not you know, how or, but when.
Again, I'm grateful to the Honourable Lady for her contribution in her speech and her intervention. I simply asked the question how, because very often that can be an issue for all of us. And I think ignoring it and trying to pretend that it isn't an issue is perhaps an easy way out for me as the responsible minister. I want to get on with this. I know that all honourable members here and honourable members with an interest who can't be with us today want to get on with it. And I accept that we owe it, not just to the families of those who have already been bereaved, but to future potential victims as well. Why do I say that with, I hope, sufficient force? It's because I've seen from my own case experience as Solicitor General what the problem is with the current maximum. And I'm grateful to the Honourable Lady, the member for Coventry North East, who quite rightly mentioned the appalling case in her constituency. It's one that I became very familiar with because I dealt with the unduly lenient sentence reference myself and presented the case before the Court of Appeal myself, because I felt there was such a strong public interest to be served that I went to appear as Solicitor General. I'm glad in that case Sir Brian Leveson, who was then President of the Queen's Bench Division, who has taken he's only just retired, but during his long and distinguished career took a keen interest in these cases, rightly increased the sentence to 10.5 years. That was a case, Mrs Moon, where on behalf of the Crown I sought to argue that in cases such as this, there was justification to depart from practice and to deal with cases of causing death where there have been multiple fatalities by imposing consecutive sentences. Because I felt that that was potentially a way to acknowledge the fact that in cases of such seriousness, that was the only sufficient way within which a court could reflect the gravity of the offending. Now, those submissions were not accepted by the Court of Appeal, and therefore we're back to the position where, unless the maximum sentence is increased, then the totality of the offending, I think, cannot adequately be reflected where there have been, for example, more than one fatality, or the course of conduct in the driving was particularly aggravated, or it was aggravated by previous convictions. And therein, I think, lies perhaps some of the answer to the concerns expressed by families about the fact that the total criminality is often not reflected by the level of sentence. Well, sentencing precedent and sentencing guidelines allow that to be done when the principle of totality of sentencing is applied. And even though a particular offence which has been charged and which might not have merited a separate penalty is recorded, that offending should and must be taken into account when assessing the totality of the sentence. So in other words, having no insurance, other driving offences of that nature should be reflected in the overall sentence that is passed on the lead offence, which would often be the most serious matter. I wanted in turn to deal with each of the excellent contributions that we heard today, and the second speech, and I'll give way to the honourable gentleman.
To the Right Honourable Gentleman for giving way. Just before he moves off the generality of the points he's been making and paying due regard to his expertise as Attorney General and the explanations he's been giving us about the complication of interpretation and definition and the appeal court not accepting what the government was trying to do, and given that he's accepting that there is unanimous support were the government to come forward with legislation, just before he moves on to individual speeches, can he give us any indication of how long it will be before the government actually comes forward with any proposals for legislative scrutiny?
I can't give the honourable gentleman a date. That is a matter of bitter regret to me today, But this debate will be used as an important platform to indicate the degree of concern now and impatience and anger that people are feeling about the delay here. And it certainly reinforces me in my determination to get this sorted out. Because, as I have been already referring to, my own ministerial and professional experience has led me to the firm conclusion that in order to deal with the full criminality of the most grave crimes under this particular definition, then judges need that space. They need that ability to use their discretion, as we have heard. Before dealing with the individual speeches, I think it would be right of me to dwell for a moment, Mrs Moon, on the important submissions made to me by honourable members, and indeed the accounts given to me by family members about their experience of the system, and my concern about hearing about aspects of the use of the victim personal statement. Now, although it would be invidious of me to intrude upon proceedings to which I've not read all the evidence or seen the transcript, I would be concerned if the reason for the editing of a victim personal statement was that somehow it would upset an offender. That seems to me to be a wholly irrelevant and inadequate explanation to be given to anybody, whether they're legally qualified or not. Surely what should drive proceedings is relevance. And having read many, many hundreds of victim personal statements, qualified lawyers and practitioners in court are well able to draw a distinction between any opinion that might be given in the statement, that might not take matters any further, but the real sense of the effect upon the victim that comes through a well-written and well-prepared VPS. Trained police officers, since the introduction of this system, have become better and better at drawing out from a victim or their family the sense of loss, the sense of bereavement, the effect, the whole effect upon their lives and the lives of their loved ones that the particular crime will have had. And therefore those documents are very important and must form a key part of the decision-making in any sentence proceeding. I was heartened to hear from some families their praise for the way in which individual judges dealt with each case, with sensitivity and with care and with precision. We are fortunate that to an almost universal extent, Mrs Moon, we are well served by our judiciary, who find these cases particularly difficult and who feel at the end of it all, and I've spoken to many of them about it, the sense of inadequacy in ever really being able to bring back or to restore to the families and the loved ones of those who have died what cannot be undone. Can I, and I'm looking at the Honourable Lady because her contribution to this debate has been significant, can I thank her not just for her speech today, but for her persistence in working with my predecessor and, of course, working with me as well to make sure that her constituents' point of view and cause is heard. And therefore her contribution today was particularly important in that respect, and I thank her for it. She asked several questions, and in particular she asked about the question of manslaughter, and she's absolutely right to talk about the existence of that offence. That has long been part of our criminal law, and it remains an available option for prosecutors in certain circumstances. Those circumstances would involve cases of the highest gravity. Case law is clear that manslaughter would be charged where the facts disclosed a very high risk of death to another person, and that therefore the type of offending that we are talking about would be very much at the very, very high end of culpability. Which is why having an offence of causing death by dangerous driving has been a very important addition to the criminal law, because it has made the test a somewhat more straightforward one rather than that used in manslaughter. And therefore, I can see huge merit in marrying up, if you like, the sentence level, that is, would be a maximum of life imprisonment, with the advantages posed by using the test for causing death by dangerous driving. Because these sorts of offences should not become some sort of legal minefield or maze. They're difficult enough for everybody involved without adding those extra complications. And that is why, although the offence of manslaughter is, of course, available and is used, we must understand that it is hedged around with particular tests that mean that it isn't always the most straightforward case to prosecute. I was asked by my honourable friend, the member for Wells, about a particularly harrowing case involving his constituents, to whom I pay tribute, and who, as we heard from him, have been through unimaginable pain. And he asked about the terribly distressing circumstances involving the loss, the death of a child who is yet to be born. And he asks me to consider what can be done to reflect the loss of such a child in traumatic circumstances. And he rightly anticipated the argument that I would put to him, which is that there is a danger that in changing the law relating to the position of unborn children, that consequences for the autonomy of mothers and the ability to take otherwise lawful action must be considered very carefully before attempting to change the law. However, it's a matter that I would be happy to discuss further with him. It seems to me that the real issue here is how to take into account the full harm, the full sense of impact upon a family in these circumstances. And we come back, do we not, to that issue of harm, and indeed how the issue is described in the current sentencing guidelines, which are now some 11 years old. And I'll read what the guideline says at paragraph 3 about causing death by driving. And it says this: because the principal, I quote, because the principal harm done by these offences is an element of the offence, the factor that primarily determines the starting point for sentence is the culpability of the offender. And there, I think it gives us a very clear indication of where the law starts from on these matters. Now, I've said that these, and I'll give way to my honourable friend.
Very grateful to the Minister of State for his reply, and I welcome the opportunity to meet with him to discuss it further. I simply reflect, however, that whatever the sentencing guidelines may say now, 3 years and 7 months for life-changing injuries to mother and daughter, and the loss altogether of a 26-week-old baby as yet unborn, seems to me that the current guidance is nowhere near adequate, or indeed simply doesn't apply well enough in those sorts of situations.
And my honourable friend makes a very powerful point, and I am perhaps illustrating in my response the struggle, the tension, the difficulty that exists here in fully reflecting the harm and the loss caused as a result of that particular course of driving. And that is why I am absolutely firm in my conclusion, and indeed the government's conclusion, that in order to deal with offences that really come to the top of not just culpability but of harm, that judges need more headroom in order to deal with those very serious offences. Now, I have already thanked the Honourable Lady, the member for Hayward and Middleton, for her important contribution, and she quite rightly talked about a case involving her constituent and his family. And again, I thank her for drawing to our attention a very powerful example of how the current law is not providing that degree of justice that so many families look to. the system to provide. And I look forward to working with her on this issue in the months ahead. The honourable gentleman, the member for Poplar and Limehouse, made, I think, an important and interesting contribution to the debate in talking about the position when it comes to road safety. And he rightly reminded us that there is no room for complacency when it comes to this issue. He reminded us that this country is amongst some of the safest when it comes to road traffic incidents in the world. And he also reminded us that despite that, there are still far too many incidents which are simply avoidable. It's important to note that road deaths, although he says they've plateaued, it is right to note that they have continued to reduce in the last 12 years. The reduction in fatalities was some 39% in the years since 2007. But I accept that that isn't actually always, and in fact almost always as a result of other initiatives that have been taken, rather than better driver awareness. We have safer infrastructure measures, we have new vehicle technologies, we have better hazard perception testing, we have better trauma care, where lives are often saved that wouldn't have been some years ago. And yes, we do, and I'm glad about this, and we all welcome this. We do have a sense of shifting social attitudes. It's been referred to by honourable members that what would have been acceptable a generation ago in terms of drink driving is no longer acceptable at all within society. Now, that's all welcome, but we still experienced over 26,000 deaths or serious injuries on our roads in 2017, of which 48 were young children. Too many of those incidents involve criminal behaviour, whether it be dangerous or careless driving or failing to stop at the scene. And every avoidable death is one too many, Mrs. Moon. It's hard to see, as I was saying, how the criminal justice system can ever adequately compensate for the loss and grief felt by families in these dreadful circumstances. But since 2012, we've seen a greater proportion of drivers who have caused fatalities through careless or dangerous driving being sentenced to immediate custody. It increased from 53% in 2012 to 60% last year. And we have also seen an increase in the average custodial sentence length for these offences. So clearly, the courts are in some measure reflecting societal attitudes and the change in attitude that we've seen to the offence of serious offences of driving. And I think that's reflected by the number of people who've signed the petition that has prompted this important debate today. So the consultation, as we've heard, took place. It was one of the most significant consultations that has been undertaken in recent years because the number of responses was considerable. And as a result of that, not only was this proposal put forward, but also two other key proposals were accepted. So the other key proposal was to increase the maximum penalty for causing death by careless driving whilst under the influence of drink or drugs from 14 years to life imprisonment. And also the third proposal, namely to provide a stronger response to offences of careless driving resulting in serious injury, which we propose to deal with by introducing a new offence of causing serious injury by careless driving, which will sit alongside the existing offence of causing serious injury by dangerous driving that was introduced in 2012. And I have to confess, Mrs. Moon, a sense of frustration at the incremental nature of the way in which we deal with driving offences. If I was able to wave the proverbial magic wand, I would like to see a thoroughgoing codification of the law to make it readily and easily understandable. But I recognise that I can't do that, and that time is not on our side. And therefore, taking the incremental approach is the best way forward if we are to achieve real change for society and for families and victims who have been affected. I was talking about the contribution of the Honourable Gentleman for Poplar and Limehouse, and I was particularly interested in his discussion of Brake's helpful and important work in this field. And I think I probably partially answered his question about a review. Tempting though it is for me to use that as a cloak for inaction, I don't think that's good enough at this stage. But I bear very much in mind what he says about the sentencing gap that is caused because of the gradation between careless and dangerous driving. Now, I don't have an easy answer for him on that, because I don't advocate coming back to what the Honourable Lady, the member for Warrington North, said in her introductory remarks about introducing an offence of reckless driving, a subjective test offence, which might better reflect the gradations in individual driving standards, but which actually, I'm worried, could make the test more difficult in terms of actually proving an offence. So it's a vexed question. It's one that needs to be properly debated, and it's one that I thank him for putting forward today. But I don't want it to be used as a reason for further delay in this area. The Honourable Lady Member for Barnsley East made an important and powerful contribution about the case of Jacqueline Wildman. She's made it to me before in the Chamber, and I'm grateful to her for having brought Jacqueline's family to meet me some weeks ago. What they said to me was powerful, it was informed, it was measured, and it was dignified. And I pay tribute to her constituents for playing their part in adding to the swell of pressure that I think is rightly being brought to bear today. So I thank her again for her campaigning in this area. That was an important case because the prosecutors used the principle of joint enterprise to bring to book those people who weren't actually driving but who were part of the course of conduct in that heavy goods vehicle. And I thought that that was a sensible use of the law, and it hopefully will send a wider message out to prosecutors that just because an individual might not be at the wheel, it doesn't mean that he or she isn't responsible for what is happening in that vehicle and what then the consequences of those unlawful and criminal acts are. So I'm very grateful to her. And then the Honourable Gentleman Member for Stroud made a distinctive contribution in which he talked rightly about the number of people who have been disqualified from driving. And he asked the question about discretionary disqualification. It was certainly always my understanding, Mrs Moon, from practice, that in order to achieve an exemption from a discretionary disqualification, one had to show exceptional hardship. In other words, hardship that was above and beyond the ordinary inconveniences of not being able to drive. Now, if that test isn't being applied stringently, then that's a matter of concern to me, because it was not intended to be some cheap get-out clause. It was intended to reflect those exceptional cases where indeed there might be real hardship, not mainly to the driver, but to dependent people who might be dependent upon that person. But he makes the general point, I think, about impunity, and also rightly prayed in aid the important work done by local voluntary groups in speed watch schemes. I myself, Mrs Moon, am qualified as a speed watch operator, and I have joined many of my local groups in my constituency to patrol roads of particular concern, with some good effect, I'm glad to say, where we have seen the behaviour of drivers change, and we have seen some greater forethought given by drivers to the quality or otherwise of their driving, particularly in residential areas. I take his point about consequences, and about how better the information that is obtained from those devices and the speed watch schemes can be used in order to improve conduct and to improve enforcement. That information is indeed usable, and I would be happy to talk further with him and perhaps with some of our local police and crime commissioners to see how we can help it achieve further crime reduction in what are our neighbouring crime police constabulary areas. So it's an invitation for us to work together, which I will take up readily. The Honourable Gentleman, the member for Inverness, Nairn, Badenoch and Strathspey, rightly drew the House's attention to the work of the Scottish Government when it comes to reducing road casualties and also dealing further with the offence of driving whilst under the influence of alcohol, or whilst over the limit, rather, I should say, of alcohol. And I'm glad to say that on the south side of the border, work continues within government to pursue the strategy that was set out in 2015 pursuant to the Road Safety Statement. That statement drew together a number of important safety measures that have resulted in a number of successful bids to the Safer Roads Fund right across the country, and also measures such as increasing the penalty for drivers who use handheld mobile phones whilst driving. The other initiatives under that particular strategy have been, and I think rightly, to allow learner drivers to go onto our motorways, therefore obtaining vital experience before qualifying rather than leaving it to after qualifying, which I always thought was a very odd way of teaching and training new drivers. And that road safety statement is one that is refreshed and one that is improved upon periodically. So this is work that is ongoing, and indeed, as always, in the sphere of criminal law, as we have done both before and after devolution, there is much we have learned from the Scottish criminal justice system that has been used here as well. And whilst I cannot, on behalf of my colleagues in the Department for Transport, make any commitments relating to drink drive legislation, we are watching with great interest the effect of those changes upon behaviour within the population, and I note the figures that he has cited today about the reduction of the number of incidences of drink driving, and I found that extremely informative. And I'll give way to the Honourable Gentleman.
Honourable General for giving way. He mentions the road safety statement, and it was welcome. It did make a difference, and it is refreshed occasionally. It's overdue by at least 6 months. The Department for Transport was supposed to produce it, and the reshuffle has delayed it even further. So perhaps he can have a quiet word with his colleague at DFT to find out when it's going to arrive.
Well, I'm grateful, and he will hear that. I'm told that it is due later this year, so they better crack on with it. Right, well, the point is made and it's understood, and I can say that because I can make promises on behalf of my colleagues. I'm sure they would do the same for me. And then the member for Bradford East, in his measured and sensible remarks, to whom I'm extremely grateful, drew together the debate in a very informative way. And he rightly reminded us that this was an issue that went beyond party politics and really should bring people together in a constructive tone. And certainly that is what I want to do with him and with other members of this House, to make the sort of progress that all of our constituents would expect us to do. I bitterly regret that I'm not able today to give honourable members that all-important timescale. But the force of the speeches and the contributions made today, I think, leave me and the government in no doubt at all about the high priority that is placed upon this reform. In fact, I would say the highest priority that is being placed upon this much-needed reform. And the force of the argument today put forward in this debate reinforces my sincere wish and drive to bring forward this reform at the very earliest possible opportunity. Let's work together to do that. And once again, I thank all honourable and right honourable members for the part that they have played in making this a wide-ranging, reflective, and I hope a debate that has struck the appropriate tone, not just for the families of those who we have lost, but for everyone who rightly wants to see that higher degree of justice when offences of this appalling nature are committed, because they are committed against all of us, Mrs Moon. Thank you.
Helen Jones to wind up.
Thank you, Mrs Moon. I'd like to express my thanks to all those who've spoken in this debate today, who have raised a number of issues around road safety, about changing the culture and about the treatment of victims. However, there is one thing on which we all agree, and that is about increasing the maximum sentence for causing death by dangerous driving to life. The Minister said he cannot give us a timetable for that at the moment, and he wants, rightly, us to work together on getting that through. But I say to the Minister, it is the government which has to introduce the bill. Yeah. It is in the government's hands. If they introduced a simple, short bill, simply to raise the maximum sentence, it could go through the House in a day, I'm convinced. If they tried to include in it other things, or heaven forbid, make it what the clerks call a Christmas tree bill, one on which you can hang anything, then clearly there will be amendments to it. So what I urge him to do is to show the relatives not words but action. Bring forward the bill, bring it forward soon, and it will have a clear, unimpeded passage through this House, I am certain. That is what people want to hear from him. That is what needs to be done. And if he has been given no timescale for it, he needs to go and have a word with the government's business managers and get a timetable for it. So we all can agree that that needs to be done, and it needs to be done swiftly. That is no less than the relatives of victims deserve. And it is no more than most of the people in this debate have been asking for today. For heaven's sake, let's just get on and do it.
Hear, hear. The question is that this House has considered e-petition 236952 relating to dangerous driving. As many as that opinion say aye. Aye. Of the contrary, no. I think the ayes have it, the ayes have it. Order, order. Thank you.
The proceeding has ended. The proceeding has ended.